Welcome to Impact Makers Radio, featuring industry thought leaders sharing problem-solving insights to help grow your business and live the life you love. And here's your host, Stewart Andrew Alexander.
Hi, and welcome to another Let's Talk Divorce conversation. And on this segment of the show, I have divorce attorney Kim Ciesinski, founding partner of Schwartz and Ciesinski LLP, who's calling in all the way from Garden City in New York. Now, Kim has a wealth of experience in the area of divorce, focuses on collaborative divorce and mediation, and we'll be talking to you today about how collaborative divorce benefits children. Now, that sounds really interesting, and I can't wait to hear what Kim has to share with us. So let's not keep her waiting any longer. Welcome to the show, Kim.
Thank you, Stuart. Thank you for having me.
You're so welcome. So, Kim, just before we get started, as we all know, there are several ways to get divorced. So could you just briefly explain in your own words, what areas do you actually focus on?
Well, after 26 years practicing as a matrimonial attorney and spending a tremendous amount of time in the legal system, I've come to the conclusion that divorce is really best handled outside of the courthouse. So in order to effectuate, I have focused my practice on collaborative and mediation. They are both alternative dispute resolution processes, and I find that they are far more effective for faster and less expensive resolutions to the issue of divorce.
Okay, so with that said then, Kim, can you briefly describe the people who come to you for help and the kinds of situations that they find themselves in when they do need your assistance?
Well, typically someone coming to see me has made that appointment because they are contemplating divorce. And I find that a large majority of people who come to see me have this preconceived notion that divorce is going to be or will inevitably become a bloodbath. And I am increasingly seeing people who don't want to engage in the legal process. They don't want to have their lives sucked into a process that they have very little control over. So let me give you a little background on the differences between mediation and collaborative law. Mediation is a process where there is one attorney who does not represent either of the parties and acts as a facilitator of communication to help the two people come to a meeting of the minds. And then that attorney drafts an agreement, and the individuals are then take that agreement to their hired attorneys for review. Because I do not represent either party, I'm not able to offer advice. I can provide an education on what the law is and express my opinion as to how certain scenarios may play out in the courtroom, but I cannot advise either party to do anything. So it's very important. The reviewing attorneys play a very, very important role in mediation. Now, mediation is appropriate, in my opinion, in a very small percentage of cases. It's really appropriate for two people who have already come to a meeting of the minds of how they want their future to play out. They are both similarly psychologically situated. In every divorce, you go through the same 5 stages of grief as you do in a death. So if both parties are pretty much on the same page in agreement that this is going to happen and they'd like to do it civilly, that's a candidate for mediation. Typically, mediation is more appropriate when you have a case with very defined issues, not particularly complex. There aren't many appraisals that need to be done in order to define the marital estate. So those cases where all of those elements come together don't happen that often. So the other end of the spectrum are the litigated cases, and those are the individuals who are nowhere near being on the same page on pretty much anything. And those are the ones that need to have a judicial resolution of their matter. In the middle, in my opinion, lie the vast majority of cases. And those cases don't necessarily need the interloping of the judicial system to assist them. Okay? Collaborative law is a team approach to the issue of divorce. It consists of 2 attorneys, one for each party, a mental health professional, and the appropriate financial expert. Sometimes that financial expert is a forensic accountant. Sometimes that financial expert is a certified financial planner. So all of the professionals for all of the topics involved in a divorce come to the table together to resolve this issue privately. At the onset of the process, a participation agreement is signed whereby both parties agree that they won't litigate this issue. So what that does is that removes the threat of I'll see you in court, and it brings the parties to the table initially with their interests aligned. So it sets the tone for the settlement process. So those are the types of people that I see now, and I concentrate my practice in the area of alternative dispute resolution.
Okay then, Kim. So keeping in mind that anything you share with us today is not legal advice or even legal assistance, can you briefly share some of the most common misconceptions surrounding how collaborative divorce benefits children?
Collaborative divorce benefits children overall and specifically in custody cases because it is a completely private, enclosed process. And oftentimes, think about it, the hot spots in every divorce are your children and your money. So with regards to the issue of children, if you can keep that out of the judicial system and resolve it in the context of a closed system with mental health professionals, that benefits children. Any time that a child is placed into the system in a custody case, they're exposed to, first of all, the litigation of their parents, which is traumatic enough. They are exposed to an attorney who represents them and will question them about the circumstances of life. And they are exposed sometimes to a forensic evaluation. It's very detrimental to a child's mental health to be exposed to all of that. In the collaborative process, you have the mental health professional who is on your team, who helps you not only get over or get through your stages of grief in a productive and constructive way, but that person helps you decide how are you going to restructure your family? What does your relationship to each other and to the children look like going forward? And the mental health professional can help people get over their anger and their frustration and their hurt and really focus on what does our family look like next. So you're restructuring, you're not destroying. Unfortunately, when custody issues get to the point that they are in litigation, there's a significant amount of destruction that takes place. So I guess the preconceived notion would be that people believe that it has to be that way, that their only option is a custody battle or their only option is to litigate, and it's not. This is a process that, in my opinion, is appropriate for the majority of matrimonial cases, particularly custody issues.
So when you say it's appropriate for the majority of those custody issues, what would be the exception to that rule then, Kim?
The exception to the rule would be 2 people who are not on the same page in terms of wanting to resolve it privately and themselves with the assistance of a team. There are people who get stuck in the anger phase. And when you're stuck in that phase, the only thing that will resolve the issues between you is a judicial determination. The problem with a judicial determination is our system is set up to produce a winner and a loser. And in the context of a custody case, you could understand how that would be particularly destructive.
Very much so. I'm just. It brings back memories to my childhood because I was a child of divorce and unfortunately witnessed a very volatile and abusive divorce, which went on for years before my mother actually decided to divorce my father. So just having these options available for collaborative divorce these days is something which I feel anybody out there who is considering divorce should definitely take a serious look at. And I know just how challenging it can be to remain, objective, to keep the emotions out of the process, just based on the memories I have with my mother. But at the end of the day, in my opinion, and I'd love to hear your thoughts on this, then, Kim, it's the children who suffer the most in these unfortunate divorce cases. Is that, am I on the right lines there?
You certainly are. That's a very accurate statement. And I mean, you just spoke beautifully to what a traumatic impact it had on you. And I'm sorry that you experienced that. It doesn't have to be that way. It doesn't have to be a win-lose situation. And our legal system is not equipped. Look, in every divorce, you have normal feelings of anger, need for revenge, sadness, grief, all overwhelming negative emotions. They're normal. There isn't a person going through a divorce who doesn't experience those emotions. The problem is when you have those emotions and you put them into the context of a judicial system, the system's not equipped to handle the emotions. So they're not normalized. Those emotions are ignored, stifled, sometimes punished. And it's a function of how the system is set up. It's not the fault of the system. It's just a natural consequence of it. It's not equipped to deal with emotional issues, and these emotional issues have to be normalized and dealt with in a secure, safe environment where people are willing to be vulnerable and discuss their needs and their fears openly without fear of retribution. So the system just doesn't, it's like, trying to smash that square peg into the round hole. It just doesn't fit when it comes to emotions.
Yeah, it's almost as if having that word fair in mind as you're going through this process can be detrimental to your own outcomes. You may have been cheated on, you may feel as though you've been treated unfairly, but those emotions could cost you a lot of time and a lot of money, if you bring those expectations to the procedure, right?
That's very true. The emotions, when you're in the context of litigation, there are so many cooks in the kitchen and so many people with agendas who are going to provide their narrative of what your life is about. It's their narrative. And oftentimes, at the point that a case is litigated, oftentimes people feel as though I've been lost in this process. I've been presented as X by this person. I've been presented as Y by this person. And none of this is who you lose yourself and your identity and your privacy. And then some tale is spun, a narrative is spun from other people's judgments of who and what you are. That doesn't happen in the collaborative process. You speak for yourself. It's a client-driven process. It is not an attorney-driven process. So you speak for yourself, and you make the decisions on how to restructure your family and what the parental relationships are going to look like going forward. And there's a place for the expression of the emotions. They're dealt with. They're not shuffled under the rug. They're not ignored. They're not punished. They are put on the table, examined, and dealt with. And that saves an enormous amount of time and cost. On average, a collaborative divorce is about a third of the price and is resolved in a third of the time. Now that's a generality and an average, but that's what I'm seeing. And it's a positive outcome. It's not you win, you lose, like when you go to court. It's a positive outcome with the goal. Everyone came to the table with the goal of coming to an agreement that meets everyone's needs, particularly the children's needs. Children are paramount in the collaborative process. And unfortunately, in litigation, children are the collateral damage, and it's unnecessary. It doesn't have to be that way.
This is a really powerful conversation. I'm so glad that you're sharing so openly with us, and Kim. And on that note, let's just go back to those misconceptions that you mentioned before. And based on what you shared with us, and obviously keeping client confidentiality in mind, could you share an example or a case study, so to speak, of how you've helped somebody who came to you with those challenges or similar challenges, and what kind of transformational results you were able to gain for them, please, Kim?
Oh, absolutely. The process has been particularly beneficial in instances where there are personality disorders or some sort of a mental illness, or in the context of a custody case, because issues like that, when put into the system, are exasperated. And by keeping them out of the system, there's no exasperation of the issue. You deal with it more appropriately and honestly and openly in the collaborative process than what would happen in litigation. And I've handled some cases that, had they gone through the litigated process, because of the mental illness issues or the custody issues, they would have taken years and years, only to come out with a winner and a loser, which is not beneficial to the ongoing relationship. And the cases that I handle collaboratively end so much quicker. But that's not the only benefit. The collaborative process, when two people fashion their own solution, they're active participants in working through the process, and they in the end come up with their version of what life is going to look like going further. Think about it. It's human nature. You are more likely to abide by an agreement that you made yourself and you were an active participant in fashioning than you are to abide by a court order, particularly if you are the loser in that court order or the perceived loser. There's just a natural propensity to abide by something that you yourself have had a hand in creating.
With that said then, Kim, if they are looking at the options of taking on the services of an attorney or a coach or mediator, whatever the case may be, but they are looking to use collaborative options or looking at those options, what are some of the pitfalls that they may need to look for when they're looking at that person providing that service?
It's very important that if you choose to do mediation or collaborative process, that you engage a professional who is actively doing that. For someone to hold themselves out as a collaborative attorney and they're not practicing it leads to a whole host of issues. You have to be trained to be part of the collaborative process. Everyone on the team has to be trained. But it's common for people to go through the training and hold themselves out as collaborative attorneys, but haven't actually ever handled the cases collaboratively. So that's a question you would want to ask. How many cases have you handled collaboratively? That's something very important to watch for.
So far, you've shared a lot of really useful information in the short amount of time that we've had, Kim. And I'm sure somebody out there who's listening to the show is probably thinking, Kim, she obviously has a lot of experience. She knows what she's talking about, but who is she? What got her into this area of collaborative divorce in the first place? So with that said then, Kim, could you briefly just tell us a little bit about yourself in terms of your background and your education and your experience as it relates to the topic of divorce, family law, and collaborative divorce?
Sure. I have been a matrimonial attorney for 26 years. And the majority of that time has been spent in contested, litigated matrimonial cases. And I came to a point in my career where I started to feel that I was becoming ineffective or somewhat irrelevant to the outcome of cases. Because no matter how smart you are and what your work ethic is and what your goals are to help, they have a way of getting lost in the system. And I became increasingly convinced that there has to be another way to resolve this family issue outside of a bloodbath, outside of the involvement of multiple professionals with different agendas. There had to be a way to bring people together with the same agenda and give them the power to resolve their issues privately. And I started to investigate mediation, began pursuing that before I began pursuing collaborative. And I realized the shortcomings of mediation rather quickly and started to investigate the collaborative practice. And once I was trained and educated on this process, I'm quite passionate about it. I feel very, very strongly that the majority of cases can be handled collaboratively. And not only does this provide a far more acceptable outcome to the parties and the families, but our system is very overburdened. So if you can remove those cases that can be resolved by the parties themselves with the assistance of professionals from the system, what you're going to do is you're going to relieve the system of some of that burden, and you're going to free the system up to do what it does best. There are cases that will never resolve unless someone is proclaimed the winner or the loser. There are many cases that truly need to go to trial. That is the only way they will resolve. But the system is so overburdened that those matters are often not given the attention that they need. So I believe that it's a win-win, the collaborative process, not only for the judicial system, for the parties. I believe that it is also a benefit to society as a whole. When you help a family restructure in a way that they remain a family, they were a nuclear family, now they will be a binuclear family, but they're still a family. And you teach them how to better speak to one another, how to communicate better. Going forward, they will be better for it. They will be able to raise their children together far more effectively than they would be had they gone through a custody case and someone was granted custody and someone was not granted custody. So that's basically how I came to this practice, and I, together with my partner, started this firm 4 years ago. And I did so because I personally would like to focus on alternative dispute resolution, and my partner is a litigator. So the firm provides all three process options: litigation, mediation, and collaborative law.
I'd like you to just picture the kind of person who comes to you for help and wants to know how collaborative divorce can benefit their situation, but more importantly, how it can benefit their children. So with that in mind, what final thoughts would you like to leave that person with who's listening to you right now?
The collaborative process is going to teach both parents how to communicate more effectively. And when the majority of marriages break down over communication issues, so if you can restructure the way a couple communicates with each other, that is going to directly benefit the child. Going forward, they will be able to co-parent more effectively, and as a result, that child's going to have a greater sense of security. When a child sees mom and dad still acting as mom and dad, that parental unit, that's far more beneficial than when a child sees two parties who are just desperately apart on every issue and can't agree upon anything.
So, Kim, if someone feels they want to know more about how collaborative divorce benefits children, how can they contact you? Where will they reach you, Kim?
My email at the firm is kmc@scdivorcefirm.com. And there is a practice group of which I am a member of professionals on Long Island who are very passionate about the collaborative process, as am I. And you can research that practice group at CRDI Long Island, Collaborative Divorce Resolution Long Island. And those professionals who are committed to this process, there are 9 attorneys, 2 mental health professionals, and 2 financial experts. And that is the team. We think of ourselves as a team that handles these collaborative matters.
Imagine it's a Monday morning and you're waking up for work. How do you actually feel when you're, in this profession of yours and the people that you're helping? How do you feel about that?
I feel wonderful about it now. 4 years ago, I didn't. I felt frustrated and ineffective. And now I feel like I am contributing something positive to society. I am actually helping people, which is what I set out to do the day I graduated law school. So overall, I feel very positive about what I do every morning when I wake up. And I look forward to coming into work, and I look forward to speaking to everyone that I help. So it's all good. Excellent.
This has been a great conversation today, Kim. So thank you so much for that. And, whether for the listener out there, whether you're cruising down the highway or you're tuning in from home or listening in on your personal device, unfortunately, we are out of time. We've actually gone over time, but I just felt our guest today, Kim Ciesinski, just had so much great information to share with us that we've allowed for more time. So with that said, ladies and gentlemen, that was Kim Ciesinski. Thank you so much for sharing so generously with us today, Kim. I can say you certainly demonstrated that you're a true educator and advocate for your client's success. So thank you.
Thank you so much, Stewart. And it was a pleasure. I appreciate the invitation.
You're so welcome. And I'd also just like to say a big thank you to you, the listener. You're the most important person. And thank you for joining us on this very insightful and informative conversation with one of the top divorce attorneys in Garden City, New York, Kim Ciesinski. Make sure you check her out, drop her an email, and you'll certainly be in good hands. So again, ladies and gentlemen, my name is Stewart Andrew Alexander, and we'll be back shortly with some more leading divorce professionals in this, our series of Let's Talk Divorce Conversations. So until then, take care, have a great day, and we'll talk real soon.
Thank you for tuning in to Impact Makers Radio. To listen to all past, present and future industry thought leaders and trendsetters, visit us at impactmakersradio.com.